Welcome back to the PI show. Before the break, we were talking about a court case that was heard in the Victorian Court of Appeal where Mrs Haley was injured in Maryborough, walking outside the Flagstaff Hotel, slipped on the footpath on a wet
conditions.
In wet conditions, and she sued. I think you said 4 people.
4 defendants, that's correct.
And she succeeded and got about $120,000.
That's right, Harry. At first instance, she succeeded in the Victorian Supreme Court, and the Supreme Court found that all defendants were liable for the mesh being on the footpath. In particular, the interesting point about this case was that the Supreme Court found the council was an occupier of the footpath under the Wrongs Act, and the Court of Appeal reviewed that decision.
And what happened?
The Court of Appeal found that actually, because it was a temporary footpath, the council were not a occupier, and it was only the council who ran the appeal, Harry. All the other defendants actually took it on the chin and walked away. But when the council ran the appeal, the Supreme Court of Appeal absolved them of all their liability and found that the standard of care was not as high for a council as the footpath was a temporary footpath.
But I think the council had granted permits and
That's correct.
had some responsibility for the footpath. But
that's correct.
Really, the falling of the mesh was really to do probably with the contractor.
Probably with the contractor, that's correct, Harry. It's likely that the council didn't have a lot of liability because the control of the footpath was given to the contractor for the purpose of the renovation.
So they had a temporary permit.
But Harry and Alice, the test against the council is a lot higher because
that's right.
You know, the formulation now is that if it's an obvious risk, you've got real problems when you're dealing with council. So really, the message to viewers is watch where you're going, because if something is obvious, you've got real problems.
That's right.
Try and establish fault against the council.
But there's occupiers who, you know, are in effect landlords or owning
shopkeepers.
Let's say Westfields, dare I say, is an occupier, and they own a lot of property around Australia.
They do.
But councils for footpaths and roads, and a lot of cases that we get inquiries from really are people who fall on footpaths.
We do.
What's the advice?
Generally, Harry, we give the clients advice that the case needs to be investigated carefully. Every case turns on its facts, but if the hazard is what could be classed as an obvious hazard, it's something that the client or that the person walking along the footpath should have seen, then it will be very difficult to establish liability on the part of the council.
And that's because an obvious risk is a defence. The council just say, look, you should have seen the uneven footpath. It's your own fault, and we don't have any liability.
That's right.
Well, a test is even more onerous than that, because to sue a council these days, you've got to actually show that there's been a written complaint of some description.
That's correct.
And then they would have gone out and inspected.
That's correct.
And at that stage, after an inspection, they've got to make a decision whether to repair it or not.
That's right.
And some of the examples...
But the written complaint means that, in effect, on notice that there is some problem that could be or should be repaired, investigated and repaired.
That's right, Harry.
And Harry, the situation's this. Once they've gone out there and inspected, they've got to make a decision whether it's something that should be repaired, if it's obvious, and there's issues about cost as well. So what they do is they basically have a look. If it's an inherently dangerous situation where it's a trap, you'd think they'd do something about it, otherwise they're going to have all sorts of problems. But if it's something that isn't that bad and not a hidden trap and things like that, you'd think that they'd probably leave it alone.
But, you know, the law as that evolved over many, many years was that councils aren't obliged to be proactive.
That's correct.
And if they don't do anything, they can't be sued. But if they're actively repairing something and someone is injured, then possibly they can be sued.
That's right, Harry.
But the issue always came back to funds, Harry. They said they couldn't possibly fix every defect in their municipality. So what they did was they basically said, have a proper plan in place to inspect your footpaths and roads. And once you've got that in place, and if you do nothing positively to rectify a problem, you can't be held accountable if it's an obvious risk.
That's correct. Yeah. It's an interesting situation, Tony, because really councils can sort of sit back on their laurels and they can do nothing to a footpath and not be held liable unless they can be considered to be on notice, as you said, about the problem. However, if they take steps to fix it and they don't do a good enough job, you have a much better chance of establishing a claim against them.
That's precisely right,
yeah. But, and let's take the case of Mrs. Katanar,
Yes.
who she was a 26-year-old who was jogging with her dogs.
That's right. She was out for a morning jog with her poodle and her terrier cross.
And she had them on long leads?
That's correct. It was something that she did all the time, is what she told the court. She was used to running with the dogs.
And what happened to her?
Well, unfortunately, Mrs. Katanar, she came across a part of the footpath that was quite broken and cracked, and she slipped and fell on it, and she fractured her femur, Harry. So it's quite a hard bone, and it's a nasty injury. Yes.
And she won in the first instance?
She did. She won in the first instance. The trial judge said that the council were liable for not fixing the footpath. However, the Supreme Court of Appeal again said that because the council were not on notice and because Mrs. Katanar should have seen the cracks, she should have avoided
She
them.
should have seen the obvious
She
risk,
said the
but
pedals blocked her view, Harry.
she blamed the dogs.
She did blame
What?
the dogs,
She
that's
blamed the
correct.
dogs.
Blamed the dogs. Said that the dogs were on the footpath, blocked her view of the footpath, therefore she couldn't be on the lookout.
She said she only saw it 10 paces or 10 steps before the actual...
But the judge in the first instance, I think, gave her $76,000.
That's correct, Harry.
So she, it was quite a nasty injury, and I think it stopped her from work for a little period of time. I think she worked in the tourist industry.
Yes, that's correct. She was working in
Harry,
the
can I
tourist
just
industry.
quickly take it back to that last case? Now, the council was found not to be responsible for Mrs. Haley's injuries. Doesn't that mean that if the other parties had appealed and she fell because it wasn't an obvious risk apart from other things, is a real prospect she would have lost as against the other defendants?
That's correct.
Because if the courts come back and said it's obvious, well,
It's almost
hypocritical.
She should have had a look out for her own. You know, she walked across this mesh, and she should have known it was risky, and she shouldn't have fallen.
That's right. It all turns on this obvious hazard idea.
At the moment, Harry, the discussion's been based around councils. I think we're still going to get into the issue of occupiers. So,
That's right.
And because we're getting to that part of the show, it's moving along pretty quick. We might have to get Alice back next week. I think.
Yeah, that looks like that's the prospect of getting
it's
her back
headed
next
that way,
week.
isn't it?
But we focus on council because there's a lot of people who do fall, trip on footpaths, and it's a common inquiry we get. And unfortunately, as you say, after we investigate it, often we've got to tell people we don't think your claim will succeed.
Yes, it is disappointing, but we do have to be realistic and tell people that.
Harry, we've got to go to a sponsors break, so I want to thank Alice for coming on the show this week. You've been very good there, Alice.
Thank you.
And I want to tell the viewers to keep watching and don't go away because we'll be back shortly with Viz Mailbag. Thank you.